You're listening to Clearly Conspicuous, a podcast series brought to you by Holland & Knight's Consumer Protection Defense and Compliance Team. Here at Holland & Knight, we have the working knowledge of how federal and state agencies operate and how courts address consumer protection issues to effectively work with our clients to address these issues.
Good day and welcome to another podcast of Clearly Conspicuous. As we've noted in previous sessions, our goal in these podcasts is to make you succeed in this current regulatory environment that's very progressive, actually, make you aware of what's going on with the federal and state consumer protection agencies, and give you practical tips for success. As always, it's a privilege to be with you today. Today we discuss the U.S. Supreme Court's recent order in Trump versus Slaughter, allowing President Donald Trump to remove Federal Trade Commissioner Rebecca Slaughter without cause. The U.S. Supreme Court on September the 22nd issued an order staying a lower court's order to reinstate FTC Commissioner Slaughter over President Trump's decision to remove her without cause. The court also directed that the case be heard on its merits in December of this year. The court issued similar orders earlier in May and June of this year, staying reinstatements of members of the National Labor Relations Board, Merit Systems Protection Board, and Consumer Product Safety Commission. So let's dive into and discuss the Supreme Court's decision. President Trump removed Slaughter as well as Commissioner Bedoya in March of this year. Slaughter sued to challenge the action, citing a 1935 Supreme Court precedent, Humphrey's Executor versus United States, which held that presidents cannot remove FTC commissioners except for the reasons specified by Congress, which are inefficiency, neglect of duty, or malfeasance. Trump did not cite any of these reasons, only policy differences. A federal judge ordered Slaughter's reinstatement, and an appeals court denied the government's motion to stay the decision. The government then made an emergency request to the Supreme Court to temporarily stay the district court's order. The administration argued that the FTC in the days of Humphrey's Executor is far different from the FTC today. By a 6-3 vote, the Supreme Court granted the stay, allowing President Trump's removal of Slaughter to stand while the justices consider the broader legal questions in the case. Procedurally, the court treated the application as a request to hear the case on the merits, and they granted the request. The court will review whether the FTC's removal protections violate the constitutional separation of powers and whether Humphrey's Executor should be overruled. The case will be scheduled for oral argument in December of this year. Justice Elena Kagan authored a dissenting opinion, joined by Justices Sotomayor and Jackson. In her dissent, Kagan cited to 15 U.S.C. Section 41, which bars the president from discharging FTC commissioners except for inefficiency, neglect of duty, or malfeasance in office. And she noted that the FTC is a classic independent agency with, quote, multi-member bipartisan commissioners whose members serve staggered terms and cannot be removed except for good reason, close quote. So with that court's decision, let's now focus on having a brief background of the FTC's history. The FTC Act of 1914 was enacted in response to growing public concern about monopolies, trusts, and unfair methods of competition during the Progressive Era. Congress sought to create an expert, independent body that could address complex economic practices in ways the courts could not easily manage. The FTC established with two primary goals. One, to protect competition by prohibiting, quote, unfair methods of competition, and two, to safeguard consumers by later expanding authority to cover unfair or deceptive acts or practices. The agency was envisioned as a preventative regulator, empowered to investigate, to study, and stop harmful practices before they solidified into entrenched monopolies. Congress deliberately designed the FTC as an independent commission rather than a single-headed executive agency. Its features include 5 commissioners, appointed by the President and confirmed by the U.S. Senate, bipartisan composition, with no more than 3 commissioners of the 5 belonging to the same political party to ensure a balance of perspectives, and staggered fixed terms of 7 years, staggered so that 1 seat expires each year, insulating the agency from short-term political shifts. This structure was intended to foster apolitical expert decision-making, modeled on a quasi-judicial, quasi-legislative body that combined economic expertise with legal authority. The legislative history shows Congress sought to create an independent referee in the economy. Then President Woodrow Wilson, who signed the FTC Act into law, argued that monopolistic power should not be policed solely through the courts, but also through a specialized, dispassionate commission capable of continuous oversight. With that background into the FTC, now let's look into that Humphrey's Executor decision. In 1935, the Supreme Court decided Humphrey's Executor versus United States, a landmark case that has guided this aspect of constitutional law for nearly a century. The case arose when President Franklin Roosevelt removed FTC Commissioner William Humphrey for political and policy disagreements. Humphrey resisted, pointing to the FTC Act's requirement that commissioners could only be removed for cause. After Humphrey's death, his estate sued for back pay. The Supreme Court unanimously ruled in favor of Humphrey's estate. It held that Congress had the authority to limit presidential removal power for independent regulatory commissions. The court distinguished the FTC from purely executive agencies, describing it as performing quasi-legislative and quasi-judicial functions. As such, the court concluded Congress could validly restrict the president's removal authority to protect the agency's independence. The court emphasized that the FTC was, quote, neither political nor executive, but predominantly quasi-judicial and quasi-legislative, close quote. This reasoning entrenched the notion that independent commissions could be insulated from direct presidential control. Folks, with that background, now let's look at the impact of the court's decision. The immediate effect of the Supreme Court's order is that Slaughter remains removed, pending decision after a full hearing in December. There is no guarantee that the court's decision will keep Slaughter removed. In its earlier Wilcox stay decision, one of the court's reasons for permitting temporary removal was simply, quote, to avoid the disruptive effect of the repeated removal and reinstatement of officers during the pendency of the litigation, close quote. However, if the court overturns or narrows the decision in Humphrey's Executor, the implications may well be profound. There will be more presidential control over independent agencies such as the FTC, the National Labor Relations Board, the Federal Communications Commission, the Consumer Product Safety Commission, and the Merit Systems Protection Board could see their commissioners or their leadership more vulnerable to removal for political or policy disagreements rather than misconduct. The president might have broader power to shape these agencies' policies by choosing to remove and replace non-aligned officials. Then there's reduced institutional independence. The role of independent regulatory bodies is often to counterbalance political influence, bring technical expertise, and enforce laws consistently. Weakening removal protections could reduce that insulation increasing politicization, and critics warn that independent agencies might become more beholden to whomever is the sitting president. Then there's the issue of greater political responsiveness and accountability. The other side of a stronger removal power is a more politically responsive and accountable set of independent agencies. Advocates argue that these agencies should reflect the policies and priorities of the American people as shown through their election of a president, rather than the aims of their own that are antithetical to their elected chief executive. There's also going to be an impact on the dynamics in litigation and regulation. If removal protections are weakened, there may be more litigation over the removal was really for cause, and what counts as cause, and what statutory protections remain. Then there's the issue of precedent shift. Overturning or further navigating Humphrey's Executor would continue the shift in legal and political understanding of the balance between Congress, independent agencies, and the president. It might also affect separation of powers jurisprudence more broadly. So with that, we've got some questions to consider. Just what counts as executive power or quasi-legislative or quasi-judicial power? If the court removes, redefines, or shrinks the category of agencies that Humphrey's Executor protects, many agencies' leadership structure and traditions will have to be reevaluated. And then, are there other presidential removal or selection criteria constitutionally valid? For instance, courts may be asked to consider the constitutionality of partisan balance requirements. And then, if the court agrees that the president can remove FTC commissioners, how broad will its grounds be? It will be important to see if the Supreme Court relies on features unique to the FTC facts of its operations today compared to the time of Humphrey's Executor, or more generally applicable constitutional interpretation. Those contours will help decide whether the court's forthcoming decision applies only to the FTC or other agencies, such as financial and labor regulators. And finally, can Congress craft around removal protections, if they're allowed to, in ways that preserve some independence while respecting presidential removal power? So folks, here's the key takeaway. The interim decision to let Slaughter's removal stand while the case proceeds signals the court's consideration of a potential major shift in the separation of power structure of the U.S. regulatory governance system. If Humphrey's Executor is overturned or sharply curtailed, it will give presidents much more authority over independent agencies with both legal and political consequences. So please stay tuned to further programs as we identify and address the key issues and developments and provide strategies for success. I wish you all continued success and a meaningful day. Thank you.
Thank you for listening to Clearly Conspicuous. For more information on our Consumer Protection Defense and Compliance team, visit hklaw.com/CPDC or email anthony.diresta@hklaw.com with any questions about today's episode.